Here's a quote. Most probably of our decisions to do something positive, the full consequences of which will be drawn out over many days to come, can only be taken as the result of animal spirits, a spontaneous urge to action rather than to inaction, and not as the outcome of a weighted average of the quantitative benefits multiplied by the quantitative probabilities. Anybody know who that is? That's John Maynard Keynes in his General Theory, written in, I believe, 1936. He's writing in retrospect of the Great Depression and, of course, the irrational exuberance that preceded it, the stock market boom and the consumer credit boom of the 1920s. Prices are very high right now in the cryptocurrency and token world. There's a lot of exuberance. Then we have to ask ourselves whether it's rational or not. With animal spirits running as they are, it's a good time, I think, to think about the things that we have in the world that are at least ostensibly designed to draw in and control those spirits, structures like government, regulation, best practices. And so our panel today is going to look at two big gray areas that surround persons who decide to develop and then sell something like a token, whether it's an app coin, whether you want to call it a currency or a cryptocurrency, whether a government will call it a virtual currency, or whether it's really something for sharing profits in a common enterprise, what a regulator might call a security. We're going to look at those two gray areas, and I wanted to just set the stage first by going through three short bits of history. Paycoin back in 2015, a fork of Peercoin, an altcoin. The developer promised immediate Amazon integration and a minimum $20 repurchase agreement after the pre-sale was to go forward. Of course, he walks away from his project, and the price of Paycoin plummets after he's collected a good deal of Bitcoin. He does basically no regulatory risk analysis, basically no compliance. SEC already is investigating him at this point for cloud mining scams, which are basically just a Ponzi. SEC is probably investigating him now for Paycoin, which is, I just want to reiterate this, a sale of an open source, poorly designed, but open source cryptocurrency to interested investors. Second, we have Ethereum. Ethereum, an amazing technology, I believe quite far apart from Paycoin as far as the real substance behind the innovation, and an inspiring group of people who made it. They offer a pre-sale in order to raise money for development, and they do it under the operation of a Swiss-chartered nonprofit, a Stiftung. I'm not going to get into the details of that because we've got someone who can speak very well to what exactly they did, and we can talk about how that fits into certain legal gray areas. And then finally, Zcash, another good example, a private placement here in the US to accredited investors only in order to fund the development of a new cryptocurrency that will promise greater financial privacy to protect human dignity. Rather than selling publicly in a pre-sale, they do this private placement, launch the technology, tokens on that network emerge through mining like in Bitcoin, and some tokens are transferred back to the original investors. These are three different models. We're going to talk about other models today, and specifically we're going to talk about them in relation to securities laws, especially US securities laws, but we'll look broadly, and also financial surveillance laws, so the laws that are created here in the US under the Bank Secrecy Act, whether you need to basically collect information about your users and customers and report that to anti-money laundering and anti-terrorism financing regulators. I have an amazing panel with me today. I'm going to let each of them going down this row introduce themselves and tell you a little bit about where they come from in this space.
Hi, my name is Emma Channing. I'm the General Counsel of the Argonne Group. We're a very young investment bank in the space, offering a turnkey solution end-to-end for ICOs. We led Blockchain Capital's BCAP. We have also ran Storge's offering, which is successfully completed this morning, and we're involved in Civic.
My name is Marco Santori. I lead the blockchain technology team at Cooley. It's a global law firm. We've been in this space since 2012, and we represent and have advised on a number of the token sales in the space. We advise a number of funds in the space, and as well as the largest exchange in the space and the other exchanges that are doing this kind of work. So we're coming at this from all sides.
My name is Tom Linder. I'm a partner with MME, a law firm based in Switzerland. And we've been in the very lucky position to assist Ethereum at that time with the incorporation of their foundation, with the structuring and organization of the pre-sale, Ether pre-sale. And since then, we've been assisting a lot of projects like Cosmos, Definity, Lisk, Golem, Singularity TV, etc., etc.
My name is Sarah Hody. I work in the Technology Transactions and Privacy Group at Perkins Coie. Prior to that, I spent over 2 years in-house at Coinbase, and most of my work at Perkins Coie is based in our fintech virtual currency industry group. And so we have over 40 attorneys working on everything from IP and trademarking to privacy questions, terms of service, and of course, everyone's favorite, token sales.
And I'm your host, Peter Van Valkenburgh. I'm from CoinCenter. CoinCenter is a nonprofit research and advocacy center based in Washington, D.C., focused on the public policy implications of cryptocurrencies like Bitcoin and decentralized computing platforms like Ethereum. So I think we should just get to it then. I'd like to start with Tom talking about the Stiftung model, the approach that was taken by Ethereum in its original sale, and how that's evolved with other offerings in the space.
Sure. I mean, the Swiss Stiftung or foundation is an entity that is very unflexible in a way that you can only use it according to the purpose that is set in the beginning. So drafting the purpose is very important. Afterwards, you cannot change the purpose anymore. And that's also the reason why the Stiftung was chosen, that the community has the security that the Stiftung will use the contributions that it has received just for the purpose of development, maintenance, and education around the Ethereum ecosystem. The contribution to the foundation is it's a little bit a hybrid transaction. Actually, in the first step, you kind of donate funds, ethers, not in that case, bitcoins in that case, bitcoins to the Stiftung, and actually you just donate it to support the purpose. Certainly the foundation promises that it will develop a protocol. However, it's not finally developed yet, so you will not get a token at that time. It will develop a protocol, it will launch a protocol, and it will include in the genesis state of the protocol a certain token allocation.
Now, you call that a donation, but there is this implied promise, at least, that in the original distribution, the person who gave the donation will get part of the stake, correct?
It's an implied kind of, or it is a proposal by the foundation that the genesis stake should include this allocation. However, there is a small risk that the community would kind of not accept this allocation, kind of already hard fork it from the beginning, and use the protocol with another token allocation. So you as an initial donor, you don't have a specific claim that you will receive the token. So that's kind of the hybrid transaction.
And in light of securities laws, which would say if you invest money in a common enterprise with the expectation of profits dependent on the efforts of a third party, that's a very fast way to quote the Howey case, which is relevant case law here in the US. However, standards are different in Switzerland, as I would understand. What saves those things, maybe, though, from being a security? What saves that promise or that implied promise of possible future shares or parts of the protocol from being classified as issuing and selling a security?
So there are different points. So certainly one is, so you don't sell a token in the beginning. So it will be part of this genesis block allocation. But since you don't have a direct claim, you don't offer like a coin or a token from the beginning. For me, there is no common enterprise because the foundation is a non-for-profit organization. There will never be kind of a profit sharing between the foundation and the token holders. Maybe the token will gain in value. Maybe you can use it on the network for commercial purposes. However, you don't have any right with regard to governments,
Right.
profit sharing, etc.
And then the other aspect is that you said you will be able to use the token. I'm assuming this is a suggestion that it's more like a Kickstarter, where you'll be able to use the thing that was crowdfunded, like a smartwatch or something like that, rather than a crypto or a crowd equity, rather, where you get a share of profits.
That's right. So you have kind of a usage function in it.
Great. Okay.
So it is an integral, it's a part of the protocol to be used. So it's kind of part of the published product.
So this is why it doesn't fit. Okay.
Distribute.
We're short on time, so we're going fast. Marco, you've worked on another interesting proposal to at least offer some clarity to people who want to go down a more regulated route or are worried about how these things look in relation to U.S. securities laws. Would you care sharing?
Yeah, and so I'm speaking obviously to U.S. securities laws. Anybody selling into the U.S. or selling from the U.S. in most cases, or some cases, are subject to the U.S. securities laws. There are areas where incorporation in Switzerland or forming a foundation in Switzerland, might come into play, but it's not the securities laws. It doesn't matter where you're selling from. If you're selling to U.S. customers, U.S. securities laws apply, including Switzerland. Peter, you took us through the Howey test, and one of the interesting parts about securities in the U.S. is that these things, investment contracts in particular, well, they can be investment contracts at one point in their life cycle and not be investment contracts at a different point in their life cycle, and so on and so forth, and back and forth and in reverse. So what we've done was something in collaboration with Protocol Labs and CoinList, AngelList, and a number of other folks, is begin the development of something called the SAFT project. Now, if you're in this room, you've probably heard the word SAFT. It stands for a simple agreement for future tokens. There's been some drafts of SAFTs floating around the valley and making their way to this coast over the last few months. The idea behind a SAFT is that you sell to accredited investors while this token is still a security. It's a security because you are reliant on the efforts, on the managerial expertise of others to develop this thing and make it into.
So under U.S. securities laws, you don't have to worry about much compliance obligations if you're selling to accredited investors. Correct?
Well, you do. I mean, the idea is that you don't have to file you don't have to register your securities publicly, right? Which is a Herculean effort for most of the folks in this room. There are some alternatives, which I'm sure Emma's going to tell us about. But with a SAFT structure, you'd file a Form D, like you would with any unregistered security, with any private placement. You'd file a Form D. You would sell to accredited investors. At some point, when this network is actually built, when the tokens work, when they have a consumptive use, and you're not relying solely on the efforts or predominantly on the efforts of others for the value of this thing, then sell to the public. Now, there are still other concerns, money transmission concerns, which we can talk about, but this is a project. This is a SAFT project. As I said, there are versions of the SAFT floating around the valley. The problem that we saw with this is that they were unconsidered. No one had looked under the hood of these things. They just took a SAFE, a simple agreement for future equity, and crossed out some terms and wrote in tokens, and that's great. That's the first step. That's what you got to do. From a lawyer's perspective, the next step is to look under the hood and check and confirm the securities laws issues, the commodity derivatives issues, the security derivatives issues, and of course the money transmission issues. And that's what the SAFT project is all about. It's about creating a standard, about creating a compliant standard that can be open source, that everyone can use, and that's the idea. From us, at least, from some of the architects behind it.
To me, it's very similar to what Zcash did, except more developed, perhaps, where you try and do the initial fundraising for the development of your technology from accredited investors, and then find a way for the tokens to reach a fair and equitable distribution to an open community, but only once they're developed. And that's important for U.S. securities laws, in part because at that point, the tokens don't appear like securities under the relevant case law. There's a line of cases dealing with golf courses, actually, where selling golf course memberships before you built the golf course lands you in jail for unregistered securities fraud, and where selling transferable memberships to a golf course after the golf course is already built is perfectly fine, which is interesting.
Important distinction that is under state law. That is a state law test. And
true.
if you guys have gone to lawyers, right, most lawyers have said, well, there's a lot of states. Let's look at the federal law. And the federal law, well, there's one test that's particularly appropriate for this, but there's state law as well.
It's the state law interpreting the Howey test, but it's not precedential. You're right.
Yeah, it's not precedential on the federal level. In any event, there's a lot to this, and we're in an early part of this story. The title of this talk is "Gray: The New Normal in Legal Compliance." I think you use the word gray area when you're. We don't like using that word. There are no gray areas in the law. There are developing areas. Just like there are no more third world countries, they're developing countries.
Okay. Emma, from Argonne's perspective, what vehicle do you see as the good way to do this sort of fundraising for development and the creation of these things? What do you work on?
I think it's important to start with a document, if everyone's read it. It's a securities law framework that was produced by Marco and Debevoise and Coinbase and Consensus and a few others.
And Coin Center.
And Coin Center. And if anyone, it's literally called the securities law framework. If anyone is thinking about doing an ICO, it's a great place to start. The vast majority of digital tokens are securities. There are a small class, particularly where it's a single key into a system, which are called altcoins, and those are arguably not securities. There are a few reasons for doing that, predominantly driving revenue back into your model, but otherwise you're basically looking at a security. And as Marco has alluded to, this isn't so much a US question, it's a global question. It is, where are you? Where are your investors? Where are your assets? And specifically, the key question is, where are you selling into? And you need to be complying with every single jurisdiction you're selling into. So the approach that we have taken...
So in other words, if you're not located in the US, but you end up having a pre-sale and selling to American investors, you need to worry about the SEC, correct?
You need to worry deeply about the SEC because the SEC has absolutely no problem with extraterritorial application, as several people in this room have unfortunately discovered. And if one of the reasons why we generally recommend complying first and foremost with US securities law is firstly because of the Jobs Act liberalizations, it's very easy to do. There's a whole variety, not appropriate for sort of this discussion, but we're always happy to chat people through the options that are available under the Jobs Act liberalizations. But secondly, if I had to pick a friend, I would pick the SEC. Because firstly, the SEC federally preempts any of the states, the CFTC, FinCEN, or anyone else coming to play. So you know the rules.
FinCEN is the regulator for Bank Secrecy Act regulations, so the AML, KYC. Did you violate our financial surveillance rules? That's now SEC's business, less than having to rely on FinCEN for this.
Yeah, and if you're an app coin, the flip side is true. So you have the bit licenses to worry about. You do have the money transmitter rules to worry about. The idea that there is some middle ground here where you are not regulated when you're issuing a digital token has unfortunately never been true. But to circle back, the approach that we take, and we recommend that, you know, Marco's colleagues are very well set up to do this. We have other people we also recommend. But you need someone with a global perspective who will say, this is how you do it across the world. We start with Singapore because in contrast to Switzerland, which relies upon a single decision relating to Ether, under Singapore law, digital tokens are de facto not securities. They're a good. So that's your first line of defense. And Singapore is very flexible. It's English law, it's common law. Tax is very flexible. And I know tax is not a discussion here, but if you're losing 40% of your income from your ICO, that's a problem. So we do tend to actually focus very strongly on your tax structuring. The next line we tend to focus on is, where is your team? Where will your assets be? And if you have any major connection to the US, we recommend you comply with US securities law. And again, it's really not anything like as hard as it sounds. And there's a lot of flexibility there because of the Jobs Act.
Now that does mean you will not be selling to unaccredited investors in the US, correct?
That's not actually necessarily true if you use Reg A+. But yes, if you want to do 506C and Reg D,
Which is
then
larger amounts, correct?
not actually true, sorry. So Reg A Plus is only available to US issuers. So that's your first problem, and it makes our tax structuring a little bit more complicated. But you can raise up to 50 million in a 12-month period under Reg A Plus, which is more than enough for most ICOs right now. And there's no limitation as to who you sell them to, at least nothing on the scale of checking whether someone's an accredited investor. And secondly, the securities that are issued, the tokens, are unrestricted securities. Whereas if you're issuing under Reg D, they are restricted and they have to be basically held for 12 months. And then you have to do some careful structuring for the manner of sale when they come off the 12 months. So, you know, one of the first questions is, where should you go? And you are more or less allowed to do what's called a general solicitation under 506C of Reg D as well as Reg A+. So say, it's really not as bad as it sounds. There's a lot of flexibility here. If I had to pick a friend to go fight every other securities regulator in the world, I would pick the SEC. No, I mean, they are the most aggressive. But you then need to basically, for the rest of the world jurisdictions, find an exemption. And there are very flexible exemptions in certain jurisdictions. For example, the EEA, so long as you have 150 purchases or less per member state, you're good. And you need to look at each major jurisdiction you're selling into. And if anyone battled all the way through the 74 pages of the BCAP offering, you will have seen at the back, we had a series of legends that said either what the exemption was or what you had to be in that jurisdiction to purchase. And this wasn't an idle exercise. This is the minimum necessary you need to do to protect yourself as an issuer, because the statute of limitations for securities fraud is between 6 years and 20 in certain jurisdictions.
6 here in the US.
Yeah. But you don't want to be worrying in 10 years' time when you take a vacation to Japan whether you're going to get stopped in immigration. And seriously, eventually the regulators are all going to come to play, and they're going to come to play on a global perspective. And if your advisors can't talk to you about a global compliance program, then I don't believe they're qualified to advise you.
So, hopefully everyone's feeling cheery now.
Sorry. There is a fix, you just have to be careful.
Yeah. So we've mostly been focusing on securities laws here. This is a type of investor protection regulation. It's the idea that people, especially people who are less sophisticated, may not always make the best decisions with regard to the business interests they get involved with, they invest in, and so we need some level of investor protection regulation to make sure that companies that offer something like a stake in their common effort are actually doing the relevant disclosures to be very transparent about what they're building and what they're not building. The Paycoin example I started off with is a great example of why we have securities laws, because Paycoin was selling this scammy token promising things like instant Amazon integration because the deal's already signed with those guys. That was just blatantly untrue. And because they were able to sell without having any registration, without having to disclose certain facts about their business, about how they're operating, this is part of the reason why people got hurt in Paycoin. Now, we can debate the usefulness of that in a world where we like permissionless innovation. Now we like companies like Uber who come in and say, I don't care about your taxi and limousine commission. I'm going to make the world a better place, or at least make you able to get from point A to point B a lot more easily and a lot more cheaply. But that debate is not a debate that's happening right now in Congress, and these are the laws that apply right now. And as Emma said, they have some pretty heavy implications. That's securities law, though. The other thing I said we wanted to talk about was financial surveillance laws, which is what I've taken to calling them because I like to be fairly transparent and not subscribe to a certain degree of doublespeak. If you hear them from other people, they'll often say things like AML KYC laws or anti-terrorist financing laws, which makes them sound like they're extremely important, and they are extremely important, but it's important to say what they are. They are federal laws here in the US and also laws abroad that deputize companies who are financial institutions to spy on their users in order to collect information on financial flows throughout the world in order to stop and interdict money laundering, in order to stop and interdict terrorist financing, in order to basically enforce the law. If you are a financial institution here in the U.S. as defined under the Bank Secrecy Act, or if you're classified as one, you are deputized. You need to register with FinCEN, the organization that enforces these laws, and collect information about your customers and report them. We've recently issued a report detailing how FinCEN's regulations and guidance on this type of law apply to both token sales and other activities in the virtual currency space. And I do believe there are substantial gray areas. I just made every lawyer on the panel go like, there's no gray area in the law. But I think there's a lot of advocacy that can be done because those laws have to face constitutional scrutiny at the end of the day. And it's one thing to deputize an intermediary who is a third party to a financial transaction to spy on their users, and it's another thing to deputize an individual selling to another private individual to sell on their counterparty. But we don't have to get into the constitutional issues. I want to now turn to Sarah Hody to talk about what those, that guidance, those administrative rulings that have been issued, the corpus and confusing corpus of Bank Secrecy Act law here in the US, and also the analogs to the extent that there are analogs in the European Union and elsewhere, what that means for token sales and what you worry about most maybe with respect to people who may not be complying.
Sure, yeah, and I'll just go back to something that Marco said, that it's not a gray area, it's a developing area. And most of us who've been around the space for a little while know that FinCEN was actually one of the first agencies, certainly in the US, to come out and actually give some kind of guidance. And at the time, I think a lot of people were like, oh my gosh, this is the worst thing ever. You can't regulate Bitcoin.
You can't regulate math. You can't do it.
Watch me try. But one of the really interesting things is that there's a flip side to it, which if you're sitting in the lawyer seat, is when regulatory bodies offer guidance, it gets rid of some of the gray area, and sometimes that's actually really helpful because it lets you operate in an area of certainty. It may be an area of certainty that you don't like, but that's a different question. And so FinCEN has been trying to work on getting rid of the gray and develop this area. And I think what they put together for Bitcoin is worth sort of repeating. They said that a convertible virtual, if you are an issuer or an exchanger of a convertible virtual currency, then you must register with FinCEN, you must have an AML compliance policy, you must perform certain financial surveillance obligations and report that back to FinCEN. But if we go back to what it means to be a convertible virtual currency, I think that's where we're going to see continued development. And I think where we can look at Bitcoin and say, well, there is no central issuer. There's no issuer of Bitcoin. Bitcoin it comes about in a distributed, decentralized way. So there's no issuer behind Bitcoin that has to register with FinCEN. So, okay. But if you're an exchanger, if you're a company like Coinbase, then you do need to register with FinCEN. And with respect to your exchange activities, you are operating as an exchanger back and forth into convertible virtual currency. But when we look at what a convertible virtual currency is, it's something that operates as money or a store of value in some circumstances, or has an equivalent value in real currency. And I think if we go back to the question of what is not actually a security, what is an app coin, then we start to say, well, okay, if this is actually an app coin, is it really operating as a currency then? And this turns into a very fact-intensive inquiry, depending on the app coin, depending on what the ecosystem is doing, and depending how you use it. So it is a developing area. But I think it's worth noting that you still may find that what you are doing is issuing, in some cases, a convertible virtual currency, or if you're not issuing a convertible currency, you may be exchanging it, in which case you probably don't want to land yourself in jail, so you should register with FinCEN, because the penalties are steep. There's a maximum penalty of 5 years jail time or $250,000 fine for not registering when you need to register.
Yeah, which can cover not just the person who invented this thing, whoever we want to call them or whatever they are legally to the company, but also their investors.
And beyond that, not even only their investors. One of the examples you'll find in BSA guidance is if you're, for example, the employee at a bank and you are knowingly violating the BSA compliance program, you could also find yourself in jail.
Yeah. So employees as well. Tom, how does the Stiftung model look at the financial surveillance issues? Basically, how does MME look at those?
Yep. Funnily, people think sometimes that Switzerland is like a regulatory haven, a tax haven, so there are no rules, you can do whatever you want, and that's just not true. So Switzerland has very strict anti-money laundering rules, it's the same rules as you have here in the US. So as soon as you are managing third-party funds, or you are an exchanger, so you exchange fiat into tokens, but also tokens into other tokens, you are under the anti-money laundering regulation. You need to have either registration with the financial regulator, or you are part of a self-regulating.
So how is the entity who's actually giving out the token not a third party in this case?
The important thing in a legal structure is then always that all the parties involved always act on their own behalf. So with the foundation model, the foundation receives the donations in order to support its purpose, but it does not hold any assets on behalf of a third party. And also it is not exchanging a token, because it's this hybrid model where the token allocation is just inbuilt in the software that is distributed. And the same.
So interestingly, so Sarah pointed out a potential way to look at the developing area of law surrounding AML in the US is this question of what is a convertible virtual currency, and do app coins fit into that? But Tom, you're describing a different way of looking at what is the developing gray area of law with respect to AML, where you may not care whether it's a convertible virtual currency or not. If it is, that's fine. But you are not a financial institution, because the BSA only applies to financial institutions. It's not a law that says individuals or persons or companies acting on their own behalf have to surveil their counterparties, because that's quite Orwellian if you think about it. We're all spying on each other in our peer-to-peer transactions. It says people who are intermediaries, it says institutions, but who play this third-party role, they're the ones who we deputize. And that's okay under constitutional law, because the Fourth Amendment has this big carve-out that says if you willingly hand over private information to a third party, you've foregone your reasonable expectation of privacy to that information. So we've got two different ways to, I don't want to say attack the BSA, because I don't think we should be attacking the BSA, but we've got two different trajectories to take that might suggest that if you're selling a token, you're not actually subject to financial surveillance laws. You don't have to KYC. You don't have to register with FinCEN or their equivalent authorities in the European Union. I'm sensing that there may be some uncomfortableness from our other panelists on this. I was wondering if you would like to address that argument.
So I think,
and in general, let's in our last 6 minutes make this conversational.
I think the approach that we take is there's two perspectives, which is, do you fundamentally object to FinCEN regulation, or do you think it's a good idea? Do you think it's a great idea that you sold your tokens to terrorists?
You ask your clients this?
Yeah, no, I think it's
because you should tell them that they should think one way or the other, I would think.
But I mean, so our general guidance is, yeah, FinCEN's a nightmare. The reporting obligations are a nightmare. Actually, the vast majority of issuers who are issuing app coins, I think, unfortunately, fall subject to it. But nonetheless, our issuance platform, Token Hub, we don't report, but we do actually follow the FinCEN guidance, because we think it's a good rule of thumb. Rule number 1, check against OFAC. You don't want to be selling to terrorists. Rule number 2, you verify who people are when it's over $2,000.
So you have them registering with FinCEN?
No, we're not.
Because they get out because of their securities?
Yep.
Okay, that makes sense.
But we still, I mean, the constitutional arguments aside, the privacy issues aside, you do not want to have sold your tokens to a terrorist. You do not want to have money laundered. You do not want to have facilitated.
That's fine, but this is an interesting thing that's bothered me for a while. When FinCEN goes after a company like Ripple, and they did go after Ripple, by the way, for selling XRP. Now, Ripple Labs didn't actually develop XRP. It was transferred to them from the original developers of the Ripple protocol. But they own it. They own it as a company, and they are selling it to persons. And FinCEN basically said, without registering with FinCEN, you violated the Bank Secrecy Act. Here's a $700,000 fine. And that's what they leveraged in a settlement agreement. So it wasn't precedential. It didn't actually go to court and test any of these things in a precedential medium, like a case law medium. But there was a settlement agreement that said that this happened. Now, in that case, we have to ask ourselves, okay, so I'm just selling something that I have. Why does that make me a financial institution? Now, if you sold it to a terrorist, I agree. Then we need to say, why did you not think about who you were selling this to? And did you have any knowledge? If you had any knowledge that that person, and by the way, Ripple did not sell it to any terrorists. What I'm saying is that FinCEN goes after you for failing to register as a financial intermediary. They don't necessarily go after you for being a money launderer. And why is that? It's because it's easy to prove guilt that you failed to register and hard to prove knowledge that you were laundering funds or financing terrorism.
Unless you're Charlie Schramm.
Unless... No, I mean, it's true. But they charged him for failing to register.
But he admitted an email. I mean, come on.
But that's fine. It's a rule of law matter. If you are worried about money laundering, you charge someone with money laundering. You don't say, oh, you didn't realize you were a financial institution, and so in this case, you can be brought up for failure to comply with the Bank Secrecy Act, which is different than money laundering. Now, Charlie Schramm's case is different because he was running an exchange, which may have been more clearly a financial institution. But if the same thing was to happen in the case of someone just selling a token, I'm not sure I'm comfortable with the result.
Look, Charlie Schramm has literally nothing to do with this. I love you both, but he had literally nothing to do with this. Arguably, what Charlie did would have been money transmission in the 1970s, right? Look, the fact is, the guidance in 2013 that said you are a money transmitter if you buy and sell virtual currency for any reason as a business. That guidance got a lot right. It got a lot wrong too. This is one of the things that it got wrong because it didn't foresee what was happening in the industry. A lot of us didn't foresee what is happening in the industry. The direct purchase and sale of virtual currency is not money transmission under the Bank Secrecy Act. It is according to
administrative ruling in 2014 that says that clearly you're selling on your own behalf.
Right. So if you are selling on your own account, if this is investment activity, if you're exercising significant discretion, these are all great indicia of what FinCEN claimed to be outside of their guidance in 2013. But the guidance said what it said. It didn't admit of any caveats. It just said if you're engaging in the direct buy-sell, you're a money transmitter. And that was wrong. That was just plain wrong. That was an incorrect interpretation of the Bank Secrecy Act and a misunderstanding of the way that the markets work today.
Now, how is that different than what Ripple did?
Well, that is allegedly what Ripple did.
Why wasn't Ripple selling on its own account and therefore not subject to the Bank Secrecy
Secrecy Act? I believe that they were, but they settled. So this has never been tested in court, except in Florida, in the Espinoza case. In fact, a Florida federal judge said, hold on, state of Florida, you mean to tell me this guy had these bitcoins, his own property? By the way, I don't think they're money. That was kind of a wackadoo statement in my opinion, but it's okay. Let's just take that as given. The judge, I think, very accurately said, look, you've got your own property. You're selling this thing to somebody. How is that transmission? Transmission is when you act as an intermediary between two people. That's money transmission. Here in the state of Florida, what you're saying is money transmission, the direct buy and sell, the direct purchase and sale of Bitcoin, that is not money transmission.
Interesting, in the Fiala case, the Silk Road case, someone selling Bitcoins to people who were using them on the Silk Road, they charge also with failing to register, failing to comply with the Bank Secrecy Act.
Of course.
And the court opinion says something very interesting, though. It says, you are now a third party because you're acting as an intermediary between the person and Silk Road because the Silk Road wallets were custodial.
Yeah, not as a business. There is errors in this logic. You must be acting as a business. Just because someone ends up with the thing but you sold, that doesn't make you an intermediary.
Okay.
One last comment on
Yep.
that. I'll just add on why this is a gray area, because while a Florida judge has now said that, and it seems maybe not consistent with what FinCEN has said, if you also talk to the Florida Department of Financial Institutions about what they did with money transmission license applications from companies like Circle and Coinbase, you'll probably get an even different answer.
So it's gray even to the regulators. That's fascinating. All right, we're out of time, folks. We're at 0. So thank our panel, please.